we turn to Alaska. This is a new case here on Court TV, the evil mother murders case for Stephany LaFountain. The 29-year-old pleaded guilty earlier this year to 2 counts of second-degree murder for the 2015 death of her 4-month-old daughter and the 2017 death of her 1-year-old daughter. Before we get you into court, here's a look back at this case with Court TV anchor Ted Rollins.
This is just an unimaginable tragedy. We have two infants, or 2 babies that were killed by their mother. How do we even imagine that?
30-year-old Stephany LaFountain is accused of murdering her 2 baby girls.
These are 2 murders that occurred in 2015 and 2017.
On November 20th, 2017, LaFountain dialed 911 to report her 13-month-old child was not breathing. The little girl was taken to the nearest hospital. She died 4 days later from lack of oxygen to the brain, and that would launch a police investigation.
The amount of work that went into this case, the innovation, the things that were done that have never been done in the entire United States to solve this case is just truly incredible.
Police discovered another one of LaFountain's children had died 2 years earlier with similar circumstances. A 4-month-old little girl from a previous relationship. Her death was not looked at the time as a homicide, and the cause of death was undetermined, but there were signs that she may have been suffocated. Police say a forensic analysis of LaFountain's internet use showed suspicious searches an hour before calling 911 for her second baby, including best ways to suffocate, ways to kill human with no proof, and how to commit the perfect murder. On August 29th, 2018, LaFountain was indicted on 2 counts of murder in the first degree and 2 counts of murder in the second degree. Then, on July 9th of this year, she pled guilty to 2 counts of murder in the second degree for the deaths of her 2 daughters.
And unfortunately, there's just nothing we can do to make this right, to make it better. But we know that we'll do what we can within the justice system to provide some type of closure and some type of peace.
This is a story about one sister whose death was ruled natural, and the mother got away with it until the death of her sister. We then shine that light on this situation and what was happening, and now this mother has pleaded guilty to killing 2 daughters of hers years apart. She's also been implicated and suspected of killing animals, a dog, a cat, fish that belonged to her in-laws. Let's get you into the courtroom now, the start of the sentencing hearing for Stephany LaFountain.
And Mr. Rosette, are you calling any witnesses?
No witnesses. I had asked that each victim be allowed 1 victim's representative. I think that's what's allowed by statute. I don't know that the statute allows for multiple family members per charge to be heard, and they have submitted victim impact statements that are part of the pre-sentence report, but I don't think it's appropriate for multiple, essentially victims' representatives per charge to be heard, but there should be 1.
What's the state's position?
Your Honor, our position is that regardless of what it may be in some instances, this particular case, the court should permit it. As the court is aware from the facts of this case, the father of Jasmine, the second child, was directly impacted by this, and he's, of course, the nearest of kin and the most one directly affected. However, the grandparents, William Sr. and Jenna, and their 2 then minor children, were physically part of what happened right after Jasmine was reported not to be breathing. So they were directly impacted personally by what happened here, not just as random people or random other relatives. So under those circumstances, the court should hear from them as well as from Mr. LaFountain Jr. With respect to the first child, Chyanne, if Mr. Peryea makes it on the line, then certainly he would be the representative for her and should be allowed to speak, obviously, on his own. But with respect to the LaFountains, there's more people affected directly by the defendant's actions in this case, rather than simply just somebody representing the child.
All right. Well, certainly the statutes set forth 1 victim representative per family, but the court is not aware of any legal authority that requires the court to hear from only 1 victim representative per victim in a case. The court will permit more than one victim representative. Certainly there's a line somewhere. It's not going to be 20 witnesses or 20 victims per child, but within reason, the court will hear from more than one representative of each family.
First, I'd start off by talking to you. What you have done, I can't even fathom. I have no comprehension to understand how you could have done that, and I don't want to see a tear from you. And not one. Because where was that when you were taking the lives of your daughters? Where was it? It stopped. You have no heart. You are a monster. A monster. And we would have given the world to you and that baby girl. And you ripped her from us. A beautiful family could have been made. I don't want to hear it. A beautiful family. My children loved that little girl. I loved that little girl. My husband doted on her. And my son was an amazing father. And you crushed everybody's world. You affected multiple lives. I've never in my life seen anything like it. The anger, the hurt, the sadness, the confusion, the frustration that you've caused my family is unforgivable. And I will never forgive you for it. The only thing I will take away from this is that I got to know that beautiful child. I got to hold her and kiss her and love her and tell her how special she was. The only thing that I can pray and hope for is that all of your evilness diminished with our love for her. And I just want to say again, thank you for letting us all speak, Your Honor. I really appreciate it. And this is, hopefully we'll be able to move along and know that because there is evil in the world, as long as there are good people, it will overshadow any of that other people can bring into your life. And that the love of my family has been so strong through all of this, and the support that we've been given from our family, the support that you could have had from our family. You have done this to yourself, and I do not understand. But that is all that I have to say, and I appreciate it. Thank you very much.
Thank you, ma'am. Is there another person here in the courtroom who would like to speak?
My name is Elise, and I was one of the aunts of Jasmine. I was lucky to know her for the time that I could. I will never forget seeing her in the hospital when just days before she was laughing and smiling and happy. I will never forget seeing you leave her before the time had come for her to come up with life support. That truly crushed me in my heart. Any forgiveness that could have been there was gone, because that showed that there was no regret, there was no remorse. when I found out about Jasmine, when I was told I was going to have a niece, I was so excited. Because my own niece and I have a bond that I will forever cherish. And I was so excited to be able to have that with her. And instead that was ripped away. I will never get to help her shop for her prom dress. I will never get to be there at a wedding. I will never get to even just to be there for her through a first day of school. You took that. And you didn't only take it away from me. You took it away from my brother, from my parents, from his mom, from his stepdad that can't be here because he passed, from my grandpa Lenny who passed. You took it from everyone. There's people who will never get to know that this day even happened because they have died. Good luck.
It's heartbreaking to listen to, but for victims, this is their opportunity to tell what they feel to this witness, to this defendant, to the court, and the court is ultimately going to be the one that confirms that sentence in this case. Next, we're going to hear from the victim's grandfather and then the father whose child was senselessly killed. Stay with us.
How we doing, guys? We're good? Okay.
You're on very shaky ground.
That is unreal. People wanted answers, and people started locking their doors.
I did not do it to hurt anybody.
You know what it means. You know what you did, right?
Please hear me out. Please.
This was a real life soap opera. And I said, OJ, everybody thinks you're guilty.
Court TV Live. Let's go back to Alaska for a sentencing hearing we are watching together in the evil mother murders case. Stephany LaFountain is the defendant. She pleaded guilty earlier this year to killing two daughters 2 years apart. Let's go back in and listen to the victim impact statement of a grandfather of one of those victims.
We would have given you anything. Given a baby anything. I've been planning on this day for so long, and now the words just start calling me. Listening to my family just makes me angry. I'm not, the sadness will come again, but right now I'm just so mad. And I can't, there's things I want to say, but that want to make me a social, want to make me a good person. And I always want to be a good person. What you have done is not good. It's evil. You've taken us, she was so pretty, so beautiful. And the last thing I have to remember is me giving her CPR. So you taking her from us is unforgivable. Put me through giving her CPR. Very hurtful. And I still don't understand why you did that. That's just, it was bad. Took me a long time. But I'll never get over this. Ever. I'm just glad I got to hold her. I got to love her. My family got to love her. And then you took it. And now you're going to pay for it. It's not justice. These are the words I can't use because there's nothing God, this court, or anybody can do to make up for this. Ever. All I can say is you'll never be able to have children. And I feel that's a blessing. Because you should never, ever be able to do this to another family again. Or a little baby. 2 babies. Thank God there won't be a third. Because I'll do everything, if you have to get out, I'll do everything in my power to make sure that nothing ever happens to another child by your hands. And I just want you to remember, you had a place in our family, and now you don't. You're going to be a distant memory, full of pain. That's all I got. Okay. Thank you.
Thank you, sir.
Liz, this is the first time I've spoken to you in 7 years. I did everything in my power to make sure that you and Chyanne were safe before I went to Iraq. The last memory I have of seeing my daughter die in person, or in our little onesie, was sorry boys, daddy said I can't date till I'm 30. The next memory I have of seeing her, I didn't even recognize her when I walked in the house because her face was so swollen, what you did. I do apologize for cussing her out. I watched her grow up through a phone. Watched her laugh. Watched her cry. Barely cry. She was not a fussy baby. One thing I want to ask you, if it's okay with the court, I don't want to just hear you say I'm guilty. I want to hear you say you murdered our daughter. If you would give me that, that would give me closure. If that is permitted.
She'll have an opportunity to speak if she wishes, but this is not the time.
I'll never get to see those baby blue eyes ever again. I got a tattoo because I wear my heart on my sleeve. It's Jazzy Rose. I'm at a loss for words. I had a victim impact statement written, but I don't know. All the anger from the last 7 years is coming out right now, and I don't know. I will never forgive you. Ever. You are dead to me.
As far as what to say here, I can say that it's been an excruciating long 7 years. The impact that this has had has honestly affected just about every part of my life. I didn't know initially about the investigation when it was being conducted, and me and Stephany had started trying to explore maybe a relationship together after everything, and to find out that the whole time we were doing that, she held this damning secret, and this evil deed is, I don't know the words to honestly express it. It makes you question absolutely every decision you make when it comes to a relationship. This event in my life, and I'm sure that the other people in the courtroom can understand what I'm saying here. It has affected relationships. It has affected friendships. It has affected my ability to trust other people, especially women. I've always wanted a child, and, Stephany knows that. We had that conversation. I always wanted a little girl. I wanted daddy's little princess. And to know that I had that and she took her from me, and not only took her from me, but turned around and took her from somebody else too, is just, it's appalling. I don't know. I don't honestly have the words to express how mortified and hurt that makes me feel. She didn't. I can't speak for Billy, but I can definitely speak for myself. We would have gladly raised those children without her in the picture if that's what she really wanted. We would have taken those girls and given them beautiful lives. For her to turn around and make that decision is just, it's unthinkable. It is one of the most heinous things that a woman can do. To murder their own child. I'm scared to have children with another woman now. I'm terrified. I struggle to even trust somebody in a romantic relationship because of the actions that my ex-fiance decided to take. And to have to wait 7 years for the system to do what it needed to do because she couldn't take responsibility. It has put everybody through hell. Through utter and complete hell. It is the most evil thing you could have ever done to us. And honestly, I don't think what you're being offered is enough. I think whatever you did to those kids, you should be put through 1,000 times. Because they were innocent. They looked to you to protect them. They gave you unquestionable trust because you were their mother. And for you to take them out of this life before they even had a chance to live it, they didn't even understand what was going on, is appalling. And I've heard that you have bragged about it while you were inside. I've heard that you acted like it wasn't that big of a deal. And whatever you got that happened to you inside is nothing compared to what you deserve. You are completely and utterly evil for taking those kids away from me and Billy.
Two fathers there speaking about daughters that were taken from them by a woman that they shared this child with, the mother of that child. Let's bring in federal trial attorney Alexis Rosenberg, who is standing by watching this case with us. And Alexis, I want to go back to, we just heard from Chyanne's father, but the father of Jasmine earlier spoke, Billy LaFountain, and he said he wanted to hear her say not just that she was pleading guilty, he wanted to hear her say, I murdered my daughter. Your thoughts on these victim impact statements?
I mean, it's just a horrible situation. I think Chyanne's father really hit it on the head. There are no words to explain the pain that she's caused to everyone, as well as, how is this possible? What was going through her head? And it was so planned out. It's not one child, it's two. When she was researching it, it really, truly is disturbing. And I agree with him. There's really no other word than monster.
Monster for sure, evil. We're going to hear that word a lot during these victim impact statements. 7 years, Alexis, they've had to wait for the system to play out, but even longer when we think about Chyanne's death. And looking at just the police reports and the details that investigators found, they were suspicious, but not enough to hold her. They saw carpet imprints on the baby's nose. They thought they saw some vomit on the floor. They couldn't get confirmation from the medical examiner who determined that the first baby's death was undetermined but possibly suffocation. What do you think else could have been done in that interim between 2015 and 2017 once this woman became a mother again?
Well, I mean, that's hard. There is a process. She does have constitutional rights. We would have hoped maybe they would have initially reported the situation to Children and Family, but there's no other child. So it doesn't seem like when the second child was born again that somehow she was not in the system anymore. I mean, I'm not really seeing that, unfortunately, there was anything that they could have done at that point.
We are going to get to a break. Alexis, thank you for that analysis. We're going to keep watching this sentencing hearing play out. We'll hear more of those victim impact statements after this short break. Welcome back to Court TV Live. Thank you for following along with us as we track several trials. Before we head back into that sentencing hearing in Alaska, let's take a look at what happened in Georgia yesterday. Chloe Driver was sentenced to prison, life in prison with the possibility of parole after 30 years. She was found guilty but mentally ill last month for stabbing her 1-year-old Hannah to death in December of 2020. Now today, Court TV spoke to someone whose name came up a lot during the Colt baby murder trial. He also delivered an emotional victim impact statement at yesterday's sentencing. Chloe Driver's ex and the father of Hannah Driver, Ben Rosenrock, formerly known as Benjamin Ben Michael. Take a listen to what he had to say to opening statements host Julie Grant.
Do you deny that you're a cult leader, sir?
I'm a cult leader. I'm a very bad cult leader. I have had the training and the aptitude to be a cult leader, but if you take classic examples like the movies or Scientology, there's an aspect of like overpraise and validation. There are certain things that go into running a cult. I'm a cult leader. I'm a very bad cult leader. I don't really have a cult following. Maybe in the time when Chloe and I were a couple, I mean, I feel like it might be closer to saying evangelist.
That was Benjamin, also known as Z, during that trial. In that interview, it's much longer. You can watch it all on courttv.com, and we'll have highlights later in the day. But let's head back now to Alaska, where we have been watching highlights from the sentencing hearing for Stephany LaFountain. She's the woman who has pleaded guilty to murdering her 2 infant daughters. We're picking it up right where we left off. The father of one of those daughters, the first one who died, and her death was undetermined until her sister died 2 years later. The father of that first baby is delivering his victim impact statement.
There's not enough hatred in the world to equate to what you deserve. You have put us through unimaginable amounts of pain. To have to sit here and wait for you to quit playing games and take responsibility. And the sad thing is, the one thing that I want to know, that I will probably never get to know, is why. You had family that was willing to help you. You had friends that were willing to help you. We were willing to take those girls and raise them ourselves if that's what it took. Why would you do that? I mean, we talked about it and we planned it. I don't know what the situation with you and Billy was, but I know ours. And we planned that. And then you just took her? There is something broken inside you. And I will never understand how you could do that. I've tried. I've gone to therapy to try and understand it. I've talked to some of my closest friends to understand it. Like why you would possibly even consider it. And I hope to God, when they give you a chance to speak, that you can give the smallest inkling of respect to us and tell us why. Because I know I want to know, and I'm sure everybody else wants to know why you would do that. I don't care what the reason is. I just want a reason. Why can I not trust another woman to have a child with her now because of what you did? There's a special place in hell for you. And I hope you don't get there anytime soon. I hope you suffer and you think about it every single day for the rest of your life. And you live with that. Because there ain't nothing on this planet that we could possibly do to you to equate to what you have done to us. And there's there's nothing we could have done to you to deserve what you did. Those girls had unlimited potential. They could have done anything in the world. And you took that from them. So I hope, I really do hope, Liz, that if you've got any remorse, that you will give us a reason. And I hope it eats you up every freaking day that you draw breath, that you did this. Because there is no forgiveness. I mean, I can forgive a lot of things, but this definitely ain't one of them. And all the stuff that you pulled after Chyanne died, the obituary, the games, and then you came to me and wanted to try a relationship again. And you knew what you did. And you still went and tried to do that with me? We were talking the day before you got arrested. The day before. You looked me in my face and you told me you had no idea why they were looking at you. So that's all I've got to ask is why. I really just want to know why. That's all I got to say.
When she gets that opportunity to speak, is she going to explain why? Is she going to give these fathers the answers that they are looking for? Coming up, we are going to get to a break, but then the state is going to ask the court for a stiff sentence for this convicted mother, Stephany LaFountain, who has pleaded guilty to killing her 2 infant daughters. We'll be back.
Go for the evil mother murder case for Stephany LaFountain. The 29-year-old pleaded guilty earlier this year to 2 counts of second-degree murder for the 2015 death of her 4-month-old daughter and the 2017 death of her 1-year-old daughter. Before we get you back into court, here's our in-court TV anchor Ted Rollins with a look at the case against Stephany LaFountain.
This is just an unimaginable tragedy. You know, we have two infants, or 2 babies that were killed by their mother. How do we even imagine that?
30-year-old Stephany LaFountain is accused of murdering her 2 baby girls.
These are 2 murders that occurred in 2015 and 2017.
On November 20th, 2017, LaFountain dialed 911 to report her 13-month-old child was not breathing. The little girl was taken to the nearest hospital. She died 4 days later from lack of oxygen to the brain, and that would launch a police investigation.
The amount of work that went into this case, the innovation, the things that were done that have never been done in the entire United States to solve this case is just truly incredible.
Police discovered another one of LaFountain's children had died 2 years earlier with similar circumstances. A 4-month-old little girl from a previous relationship. Her death was not looked at the time as a homicide, and the cause of death was undetermined, but there were signs that she may have been suffocated. Police say a forensic analysis of LaFountain's internet use showed suspicious searches an hour before calling 911 for her second baby, including best ways to suffocate, ways to kill human with no proof, and how to commit the perfect murder. On August 29, 2018, LaFountain was indicted on 2 counts of murder in the first degree and 2 counts of murder in the second degree. Then, on July 9th of this year, she pled guilty to 2 counts of murder in the second degree for the deaths of her 2 daughters.
And unfortunately, there's just nothing we can do to make this right, to make it better. But we know that we'll do what we can within the justice system to provide some type of closure and some type of peace.
Let's get you back into court now for more of LaFountain's sentencing hearing. Again, she faces up to 20 years. We're picking it up right where we left off with the state's final argument before the judge hands down the sentence.
The other important facts that I wanted to remind the court and this is ultimately because of the probation conditions that the state is requesting in this case, is the information with respect to the animals. Animals certainly are nowhere near the situation with her killing 2 babies, but it does tend to show a little bit about what goes on in her mind. As the court is aware from the filings in the case, there was a cat owned by her and Patrick back in 2014 and 2015. When Patrick ended up by going to jail before Chyanne was born, she told him, well, I took the cat to the vet and the cat was sick, so I just let her go in the woods. Basically abandoned her to die in the woods. Of course, interestingly enough, research indicated that she had taken that cat to no veterinarian in Fairbanks or North Pole at any point. In addition, Brian Wood commented that he had seen the cat, he was there with the cat, and the cat was fine within a day or 2 of the cat suddenly being dumped in the woods and left to die. While pregnant with Jasmine, Billy had a puppy, a 7-month-old husky mix named McKinley. He was in the field, she was in charge of the puppy, and she called him in the field to say, your puppy fell down the hill and broke her neck. He rushed home to find that the puppy was in fact dead, but was not covered with any mud from the purportedly muddy hillside that the 65-pound dog had supposedly been dragged up by a pregnant woman. But she had some feces on her side and was indubitably dead. The necropsy that was done by the police later, or done at the direction of the police later, indicated there was no indication of the dog having broken her neck. After Jasmine was born, the defendant and Jasmine went outside to meet with the in-laws and drive back up to Alaska with them. While there, they were packing up to leave, and the children had to bed a fish. The defendant said, what a nuisance to travel with a couple of fish. Why don't you get rid of them and get more when you get to Alaska? I'm being told that they were the children's pets and that they loved them and it wasn't a big deal and they were traveling with the fish. She thought it was a nuisance. Within a very short period of time, minutes after the children were in bed, she came in and told Jenna LaFountain that your fish is sick and it smells like there's lighter fluid in their tank. That lighter fluid had been left on the counter, but Jenna had personally just put the fish in the travel tanks with fresh, clean water. And then when determining that the fish were now dead, the defendant said, well, now at least don't have to worry about the fish when traveling. A couple of months before Jasmine died, the defendant got a kitten named Polar. She sent pictures to Billy while deployed, among other things, which was useful in the long term because when the kitten was 3 months old, only a couple of weeks before Jasmine died, she told Jenna LaFountain that the kitten was going to have to go because she had scratched the baby. Well, Jenna looked and the baby had a couple minor scratches, nothing she would have ever worried about if there was any issues. But she said, we'll take the kitten. My son, the younger LaFountain, Aiden, loved that kitten. We'll take the kitten. She said, well, we'll see about that. Goes home, and then within a short period of time, messages Jenna and says, the kitten must have heard me saying I was going to get rid of him. He ran away in the snow in November in Fairbanks at 3 months old. Everyone assumed that Polar was dead at that point, but further investigation revealed that an MP being told, interestingly enough, by the defendant, calling it in, saying there's a cat crying in the area, no information about it being her cat, but a cat crying in the area, went out and looked and discovered that there was a single set of human footprints leading from the back of the defendant's house to the fence, and on the other side of the fence, a hole in the snow with a hypothermic 3-month-old kitten in it. She rescued the kitten and turned it over to the animal shelter, and the kitten survived and was adopted out. Amongst other things on the search of the phone that showed these internet searches right before she killed Jasmine, a couple of weeks earlier or so, there were internet searches asking about what antifreeze will kill a dog and what will poison a dog. She had another dog at that point. So, over that 2-year period, she murdered 2 children. But apparently she did not see the children as substantially different from the various pets that were, whether hers or somebody else's, were a nuisance to her as well. And she killed them or attempted to kill them. It was all pretty much the same difference, it seems like, to the defendant. With that background in mind, I want to remind the court the reasons for the agreement here. The court is aware this is a compromise between the parties. The ongoing litigation with respect to the motion to suppress evidence from the phone, which is obviously extremely key evidence in the case, and other things related to that litigation, ultimately meant that the most important thing here was that the defendant take responsibility for murdering her 2 children, that she be convicted of those murders, that she remain in custody for a substantial period of time, and that at such point as she may get out of custody, that she will be able to be supervised for as long as possible on conditions that will ensure that she does not have access to kill any other vulnerable people, or for that matter, animals in the future. It's true, she does not have any prior record, and as noted in the defense memo, these sentences are within the page benchmark, which is to say the Alaska law that indicates that first, second-degree murder convictions should result in a sentence somewhere between 20 to 30 years of active time. Those do fit in this case, and that's what she's getting. Obviously, she probably deserves a great deal more, but the agreement is appropriate because it takes into account all of those different factors that led to the parties reaching an agreement. It also takes into account the fact that the court can protect the public with the suspended time and probation as well as the active time. The reasons the defense have essentially agreed with the state's recommendation of the 10 years or max probation. So I won't go into any further detail on that other than it does need to be as long as possible to protect the public. They do disagree with the amount of suspended time requested. The state's request for suspended time, as the court is aware, we're asking for 65 years with 40 suspended on count 2 and 65 years with 45 suspended on count 5. For a sum total of 130 years with 85 suspended, leaving the agreed upon 45 years of active time. That additional 85 years is necessary for several reasons. It's necessary to protect the public. It's necessary to protect any potential future victims of the defendant's lack of any empathy for others who are vulnerable and that are even briefly in her care. It's necessary to reflect the community condemnation and reaffirmation of societal norms in a circumstance whereby a person has chosen to kill both of her children, and not in one terrible moment of, oh my gosh, what was I thinking, but 2 different times, 2 years apart. It's necessary to act as specific deterrence for her to ensure that she doesn't come anywhere near violating her probation at such point as she may be released. to make sure that she knows if she commits any further crimes or violates her probation, there is a high likelihood that she would never see the light of day again after that. The specific conditions that the state has requested, as noted, they are related to the conditions that were requested by probation. In fact, we agreed with all of them with those couple of variations that I mentioned in the sentencing memorandum. But the specific ones that we wanted to make sure, because she's, as far as we know, she's not involved with drugs, she's not involved with stealing, she's not involved with any of those kinds of things. What she's involved with is anyone or anything which is vulnerable and a nuisance or inconvenient to her is at risk from Stephany Elizabeth LaFountain. And that includes children. I would have stuck with babies, except that small children are vulnerable. Actually, older children are vulnerable. If the court wants to say at what age is a person not really vulnerable enough to be at risk from her, it doesn't have to be 18, it could be 15 perhaps. But I would urge the court to consider what age a child is legitimately no longer vulnerable from someone who will just get rid of them if they're not convenient to her.
Before we head to break, an update on the Wisconsin kayaker who faked his own death and ran off to Europe. We told you Thursday that Ryan Borgwart had returned to the United States, but now court records show his wife Emily is seeking to end their marriage. She is also asking for sole custody of their 3 teenage children. The couple has been married for 22 years. A hearing in the case has been set for April. Ryan Borgwart is out on bond and is charged with obstruction. Still ahead, stay with us. More from the sentencing hearing for Stephany LaFountain. Up next, the state argues that the convicted mother should not be around any children or vulnerable people as part of her probation. Stay with us. We'll be right back.
Tonight, on closing arguments, a kayaker who allegedly faked his own death and fled the country is now in custody. We're diving deeper into this case as our experts weigh in.
Closing arguments tonight at 8, 7 Central, only on Court TV. Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates tonight, 9, 8 Central, only on Court TV.
Back to Alaska now, where we've been watching key moments from this week's sentencing hearing for Stephany LaFountain. She's the woman who killed her 4-month-old daughter in 2015, and then 2 years later in 2017, she killed her other daughter. Look how beautiful they are. That daughter was 1 year old when she was killed. We're picking it up now with the prosecution's final argument at the sentencing hearing.
She needs to not be in charge of or essentially left alone with elderly or disabled persons who are either no longer or never able to protect themselves from her deciding that they're a nuisance and that she doesn't need them around anymore. And frankly, she doesn't need to have any pets. She doesn't need to be around or be left alone with anybody's pets. I mean, she's shown that she's willing to kill anything from betta fish up to kittens and puppies. If she wants to go fishing for food, that's fine, but if it's a pet, she shouldn't have any contact. I want to remind the court that the issue about her killing the pets was suppressed for the jury purposes to ensure that they did not make a decision with respect to the murders of the babies on some other improper grounds. That does not mean that it's not highly relevant for sentencing, because among other things, it explains what goes on in her mind. It isn't a good explanation for why she killed 2 innocent babies, but it tells us a little bit about her state of mind. She doesn't have empathy for things that are weaker or vulnerable than herself. She doesn't find that any of them is important enough to have their own life or be turned over to somebody else to take care of if she just simply can't deal with it anymore. it tells us that she doesn't really seem to differentiate between people and animals as far as their worth. None of them is worth anything for her. And of course, ultimately it explains why it's important that she be precluded from contact not just with babies and small children, but with elderly and disabled people. And so I would urge the court to consider it for all of those reasons. Ultimately, she was never tested, certainly by the state. I have no idea whether the defense had her tested for psychological issues. But from a layperson's perspective, her actions appear to be, frankly, sociopathic. They seem to be someone who has no empathy for people or animals, anything that's weaker than her. If it's a nuisance, it can go. Ultimately, Your Honor, the state's recommended sentence is the appropriate one in this case. The seriousness of the case cannot be overstated. There is no sentence that this court could impose, and you've heard it through the victim impact statements as well, that could ever restore these children or their families. There is honestly no sentence that could truly reflect the societal condemnation for her actions. But, I mean, she treated her own children as disposable. She doesn't have any other criminal history, but her rehabilitative potential is bluntly low. She wasn't drunk or on drugs. There's no known mental health conditions. Like I said earlier, the only likely answer is some level of sociopathic tendencies, which is evinced by her lack of empathy and compassion. The harm to the victims and the public is incalculable. 2 infant girls were deprived of their entire lives, not by accident, not by someone just randomly spraying bullets, but by their own mother who chose to kill them rather than ask anybody to take them or to take care of them. 2 fathers will never get to see their little girls grow up. The extent to which these offenses harmed the victims, the families, and the public can't be stated ultimately in words. Under these circumstances, Your Honor, imposing the substantial period of suspended time, the maximum probation, and the strict conditions recommended by the state is the best way for the court to meet the Chyanne criteria, reaffirm societal norms, properly reflect community condemnation, ensure specific deterrence of the defendant, and protect the public in the future. And we would ask the court to impose it for those reasons. Thank you.
Now let's bring in, joining us now, criminal defense attorney Dwayne Cates. Dwayne, of course, thank you for being on with me. Listen, I thought the state laid out a very compelling case for the amount of sentence of time in jail the state's requesting. A total of 130 years, 65 on 2 separate counts, with 85 years suspended, meaning there would be 45 years active time, especially given the descriptions of the killing and disappearance of pets in the life. 2 girls murdered based on the guilty plea by this individual, and that she doesn't have any empathy. Your thoughts?
Well, first of all, my thoughts are, you know, I'm a little confused that the defense didn't have a psychological expert do something for sentencing. Now, that doesn't mean they didn't have one, because they could have done testing and it could have turned out bad, and they didn't give it to the state or to the judge. But that's always a bad choice when you present no psychological evidence. The prosecutor's right. You know, you can assume that either it was bad or they didn't do any testing, and I don't know which one it was, but it had to be one of those two things.
Yeah, I noticed that as well. I was even surprised, and I want your take on this, that she said the prosecution, the state, did not have her tested for any psychological issues at all, but she does seem to have I can't remember the word, sociopathic, that's what she said, tendencies. Yeah. And so, are you surprised that the prosecution didn't take it upon themselves to do an evaluation to see what's really going on?
Well, they don't need to. See, the lack of a psychological evaluation, they get to speculate that she's a sociopath, okay? And you have nothing to prove against it. It's the defense's job to have the defendant tested and to put on a defense. And you think postpartum depression could be an issue given the young age of the children when they were killed. I mean, there's a lot of things that quite frankly may have been going on, psychologically, but we will never know because she was never tested, or if she was tested, it turned out so bad that the defense doesn't want to present it.
Right, and I have to say this, you have to hope, you have to think, hopefully there's some psychological issue, because the reality is this kind of cold, calculated killing of a 4-month-old, and then 2 years later, a 1-year-old, along with fish, puppy, kittens. I mean, have you in your experience seen something like this where there wasn't some type of trauma or psychological issue in the person who committed these heinous crimes?
Well, quite frankly, I haven't. And again, sometimes you can have people tested and you can have your psychologist write limited reports, leaving out the bad stuff. And then it would be up to the prosecution to have their own testing done. But I've never seen it where there wasn't something going on. And quite frankly, at sentencing, it doesn't get worse than having dead kittens, puppies, and children. I mean, it just doesn't get worse than that.
Yeah, I agree with you. And when I was listening, I thought, man, what happened to her that she ended up being this kind of criminal? No criminal history. Significant, but the state said, even though that's true, you cannot overstate the seriousness of these crimes. You're going to stay with us. Thank you for that. Coming up next, the defense argues for a lighter sentence for convicted mother Stephany LaFountain. We'll see whether or not they had a psychological done. Stay with us. We'll be right back. Order. North Carolina this hour, where the jury in the convenience store murder trial is currently on a jury view of the crime scene. Now, earlier today, the judge granted a defense motion allowing the jury to visit defendant Taz Zarka's convenience store. This is the store in which he's accused of fatally stabbing a customer. Prosecutors say that Zarka used unnecessary force when he caught Mark Garrity shoplifting. But the defense says it was self-defense after Garrity attacked him. Now for my thoughts from the bench on this. Jury views are exceedingly helpful for jurors to really be able to visualize the crime scene firsthand. Of course, there are many logistics to consider as a judge, including the safety of the public and the safety of the jury. Generally, there needs to be more probative value than prejudicial value. In this case, the videos from inside the store, the crime scene, make it clear that space was limited in the aisle. So I really think it's imperative to allow the jury view, as it will make it easier for the jury to determine if it's reasonable to believe the defense's version that the victim stepped back and then moved toward the defendant, resulting in his self-defense claim. This is a reminder that the judge has to manage so many logistics in rendering decisions, making certain that the deputies are available not only to assist with safely transporting the jurors, but also to protect the judge and to stand guard and keep the public away to ensure there's no prejudicial behavior by the public during that jury view. Making certain that the store's closed so that the view is non-biased for the jury. So allowing a jury view, especially in a case like this, is a heavy lift for a court, but it is most often helpful and not prejudicial with the right court-ordered safeguards. Those are my thoughts from the bench. Now let's turn back to Alaska for more highlights from the sentencing hearing of Stephany LaFountain, the woman who pled guilty to murdering her 2 infant daughters. We're picking it up now with LaFountain's defense team arguing for a lighter sentence.
I want to begin with addressing one of the last things that the state addressed in its sentencing comments, which is to say that The record of behavior here is clearly not the product of somebody who is mentally well, and I think it's important for the court to understand that it shouldn't come as a surprise that we have sought the help of mental health professionals in our representation of Ms. LaFountain. There are a variety of reasons why we wouldn't want psychological evaluation to have become part of the sentencing record, but it is the case, and it seems plainly evident given that there, Ms. LaFountain is coming before the court to plead. She already has pleaded guilty to murder in the second degree with respect to her children. This isn't something that somebody just does without there being mental health issues. So, I don't say that to excuse any of her decisions, and I certainly don't say that to imply that there is any kind of legal excuse or even explanation for Ms. LaFountain's behavior. But Ms. LaFountain is going to be, she's going to have to live with the decisions that she's made, and she's going to have to live with a commitment towards getting her mind and really her soul in a better place going forward. So the sentence that the state and Ms. LaFountain have agreed upon does reflect the posture of the case as it was, and Ms. LaFountain certainly understood the risks of proceeding further with litigation, proceeding with the trial, and the state understood the risks from their perspective as well. So the agreement that the parties have come to is appropriate with respect to the time to serve, and the court should accept it. As Ms. Creel mentioned, it is, each sentence individually is within the page range, and then each sentence is entirely consecutive to one another. So it does exceed the page guideline, so to speak, by good measure, and is going to keep Ms. LaFountain in custody into middle age at a minimum. And that does reflect, to a significant degree, a sentence that incorporates all of the Cheney sentencing factors and makes it so that Ms. LaFountain receives the appropriate period of confinement, reflects community condemnation, reflects the severity of offense, and we would ask the court to accept the agreement as to time to serve. The amount of suspended time that the state is seeking is excessive. Essentially, it's approaching the, if there are violations of probation, approaching the maximum. It's not quite at the maximum, and I think that the state, acknowledges that for the court to impose the absolute maximum, it would have to make worse offender findings, and so they stopped just short of that. But that's functionally what the state is asking the court to do with, ask for upwards of 80 years of suspended time, or at 80 years of suspended time for these offenses. 30 years of suspended time is a significant amount of time. I mean, the overall sentence at risk for Ms. LaFountain would be 75 years. She's in her mid-20s now. I mean, that's functionally, it puts her at risk of spending the rest of her life in jail, even if the court accepts the sentencing recommendations that the defense has made. But there isn't a reason to put her, at risk of just simply imposing 80 years in the instance of a probation violation. Ms. LaFountain is going to make a statement in a moment. She wants the court to understand that she is coming to this conclusion of the case in order to take responsibility for her actions, that she acknowledges the pain that she's caused both families and their extended families. She will be on probation for a significant period of time. After she's going to be released, she'll be on parole in all likelihood when she's released, so there's going to be a substantial amount of supervision in her life, and that supervision should be geared towards making sure that she gets the help that she needs so that she doesn't come before the court again. Quite a unique set of circumstances, and the reason that Ms. LaFountain is objecting to the probation conditions as they've been imposed by the court is that, I'm sorry, that the state is asking the court to impose with respect to contact with children is that, you know, she's going to be in custody through her childbearing years, Judge, and so the chances that she has a child of her own are minimal here. And in a weird way, you know, frequently we come before the court for, say, folks who are convicted of child sex offenses. And the state, you know, quite rightly asks for probation conditions preventing folks from, with those kinds of conditions, from having contact with any children whatsoever. This isn't like those cases. This isn't like Ms. LaFountain poses a danger to any random child. That's not really what the record bears out here. There were the specific circumstances in her life and in her, you know, interior life that led to these situations. It's not appropriate to just say she should never have any contact with any children whatsoever when she's in middle age after having served this, you know, a couple, 3 decades, maybe more in custody, and then will be on strict conditions of probation afterwards. So what the state is asking for with respect to contact with children is constitutionally overbroad and doesn't pass muster for the court to impose those. But ultimately, we're talking about a very long period of time from Ms. LaFountain to be in custody. We're talking about a very long period after that she's going to have supervision. We're talking about a very long period that she has at risk if she violates her probation. And all of those things add up towards a sentence that meets the Chyanne criteria. We would ask the court to accept the agreement and ask the court to accept the defense's recommendations for the amount of suspended time.
The defense arguing that the state's request for a sentence is excessive. And coming up next, you don't want to miss it, the convicted mother herself, Stephany LaFountain, she addresses the court. Stay with us. We'll be right back on Court TV Live.
How are we doing, guys? We're good? Okay.
You're on very shaky ground.
That is unreal.
People wanted answers, and people started locking their doors.
I did not do it to hurt anybody.
You know what it means. You know what you did, right?
Please hear me out. Please.
This was a real-life soap opera. And I said, OJ, everybody thinks you're guilty.
Back to court in just a moment, but first we have an update out of Vermont where Joseph Orlazzo was found guilty earlier today. The jury deliberated for about 3.5 hours over 2 days before finding the former tattoo artist guilty of killing and then dismembering his wife, Emily. The couple had been on a trip to Vermont. At the time, they were celebrating their 1-year anniversary when Orlazzo fatally shot Emily. Now, he took the stand in his own defense earlier this week, and he said he was physically and verbally abused by Emily and that he had shot in self-defense. Clearly, the jury did not believe what he had to say. A sentencing date has not yet been set. We will continue to keep you updated on any new developments in that case. For now, we are in Alaska for the Evil Mother murders case against Stephany LaFountain. She pled guilty back in August to 2 counts of second-degree murder for killing her 2 infant daughters 2 years apart. Let's head back into court now where LaFountain is about to address the court before the judge hands down her sentence.
Ms. Bialecki, you have the right to say anything that you'd like at this time. You're not required to say anything, but this is your opportunity. Is there anything that you would like to say?
I should let the court know Ms. Bialecki sent me a statement, and she's going to read it off of her computer with this. These are her own words.
All right.
First and foremost, I'm so sorry for the hurt, the pain, and the confusion that that he must feel daily from the selfish, life-altering decisions that I've made. I was arrogant, prideful, a liar, malicious, and overcome by so much anger for who I was becoming. I blamed it on those around me. A family and a devoted, loyal husband that only chose to accept me, support me, and show me love with no ulterior motives attached. I took all of this and so much more for granted and hurt innocent lives in the process. We are never promised tomorrow, but here I am today, breathing another breath, while my own daughter has never got to see the true beauty of this world. Or feel the love. Or feel the love of their blended, amazing families that saw the sun rise with every smile on their beautiful face. God promises us a future and a hope. How is that fair to accept when my decisions removed school picture day from a reality, learning to ride a bike, or most important, a father having his daughter run into her arms for the first time in both of their lives? I can never change the past, but I pray every day for your family and loved ones to heal and to remember all the blissful moments. And hopefully one day forgive me so we may all feel the peace that surpasses all understanding. But never forget Chyanne and Jasmine. They are forever. They will be missed, loved. They are accepted and a true joy for eternity. Thank you for your time. I wish I could give you an answer. I wish I could give you an explanation. I'm sorry.
Okay. Ms. Biloquet, I don't want to cut you off. Was there anything more that you'd like to? That's it. Okay. All right. The court is going to take a recess at this time to consider everything that's been said, and then we'll come back and pronounce sentence.
Well, she was certainly different than many defendants we see. She was so overcome with emotion, still with us to help analyze this, criminal defense attorney Dwayne Cates. Dwayne, did you believe her? She says, I'm sorry. I'm so sorry for the hurt. I'm sorry for my selfish life. I was arrogant, prideful, malicious. I was so angry. Did you find her believable?
Well, somewhat. I mean, the emotion was real, okay? And it's possible for somebody to do horrific things and then be extremely remorseful afterwards. And I think she was. But I think that, I try not to write things for my clients to say, and the verbiage that was used was a little bit, sounded like maybe a lawyer helped her with what she was trying to say. And I also advise my clients to not read statements, to just get up and speak from the heart, good, bad, or indifferent, when they address the judge at sentencing.
And it's interesting because I thought I heard, and some of it was hard to hear, I think her attorney said to the court, these are her own words, but then I agree with you as she started to read it. Sometimes that feels different when I was on the bench to have someone read it versus speaking from their heart directly to me. Now, the other thing, all I could think, Dwayne, I'm like, I can't wait to get Dwayne back on, because to me, what this statement says is that the defense probably did have some testing done, and it probably wasn't helpful to them to use any psychological testing at sentencing. Your thoughts?
Yeah, I mean, if it came back border personality disorder or the psychopathic tendencies, then that's not good, and that would be an argument to keep her locked up longer. Okay, so it must have come out bad, and I was kind of shocked at the beginning that they didn't have testing, but yeah, there was testing done. It probably just didn't come back good for her.
Yeah, that's what I think too. Now, if you were hearing this case, knowing the facts with the puppy, the kitten, the fish, two little girls, two different years, 2015, 2017, a 4-month-old, a 1-year-old, all killed by this mother, what type of sentence do you think she might receive?
That is a totally unfair question to a criminal defense lawyer.
It's Friday. I'm sorry, Dwayne. Yeah, tell me your thoughts.
I generally don't. I generally don't. But again, I don't know the specific scheme in Alaska. I mean, it seems like, 45 years, it seems like she would do considerably less than that. Arizona has truth in sentencing, and in homicides would be flat time. So in Arizona, if she got 45 years, she would do 45 years. It sounds like she's going to be eligible for parole at some point and then have a bunch of time hanging over her head. And I think that's probably appropriate.
Yeah, I think that's the case as well. And the defense attorney did say that she, regardless of the sentence handed down, would be in jail during her childbearing years and would not have any more children. But I just have to ask you really quickly in the last 10 seconds, that's not necessarily true because there are inmates who have children not on an irregular basis.
Yeah, that's true, and especially if they put transgender people in the cells with, in the prisons with them. And some of them are allowed conjugal visits and get pregnant in jail. So that is possible, but I think there's going to be restrictions to her having children.
Yep, we'll see. All right, coming up next, Michael Ayala joining me for the judge's sentencing. Plus, we hear from the defense's final witness in the convenience store murder trial before the jury visits the crime scene. Stay with us. Back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We're both here today giving you your front row seat to justice. And we are in North Carolina this afternoon where day 3 of testimony is underway in the convenience store murder trial.
Defendant Taz Zarka is accused of stabbing to death 27-year-old Mark Garrity after he witnessed him shoplifting in his store.
Now, Zarka informed the court earlier today that he would be testifying in his own defense. But first, the jury is actually getting to visit Taz's convenience store where the stabbing took place. Now, we're going to get you back into that courtroom in just a moment.
I just have to ask you quickly. I think it's a good thing they get to go see that convenience store. What are your thoughts?
I'll tell you what, after hearing arguments today, I wasn't so convinced. I was initially, but now I'm not so convinced.
Oh, we're going to see what the jury thinks and what happens in that case. But first, we do want to turn back to Alaska for the evil mother murders case for Stephany LaFountain.
The 29-year-old pleaded guilty earlier this year to 2 counts of second-degree murder for the 2015 death of her 4-month-old daughter and the 2017 death of her 1-year-old daughter.
But it wasn't until the second daughter's death that police began to investigate and then discovered that LaFountain had concerning searches on her phone in the hours before she called 911, including one search for, quote, ways to kill a human with no proof.
All right, I want to get you folks back into that courtroom now for the judge's sentencing.
In terms of the seriousness of the offense, the court starts from the premise that every murder is of the utmost seriousness and every murder inflicts incalculable loss on the victim and the victim's loved ones. However, even compared to other murders, Ms. Bilecki's actions here were of extraordinary seriousness. She chose victims who were utterly helpless and who relied on her, their mother, to protect them and meet their needs. As noted earlier, Ms. Bilecki did not commit these offenses under the influence of any substance or as the result of any known mental health diagnosis. It is difficult to conceive of more serious conduct constituting the offense of murder in the second degree than a mother's actions in deliberately taking the lives of a 4-month-old infant and a 13-month-old child in incidents 2 years apart. Ms. Bilecki has no prior criminal history. However, her likelihood of rehabilitation appears quite poor, since these offenses were not the product of substance abuse or any known specific mental health defect. There is no treatment the court can order to address the underlying causes of her conduct. As quoted earlier, the Court of Appeals has held that incidents of unexplained and unprovoked violence may indicate that an offender is seriously disturbed and unusually dangerous. That quote applies precisely to Ms. Bilecki. The 2 murders here were the epitome of unexplained and unprovoked violence against extremely vulnerable victims. In these circumstances, there is little, if any, hope for rehabilitation. Without any reason to believe that rehabilitation is likely, there is a strong need to confine Ms. Bilecki to prevent further harm to the public and especially vulnerable children. When Ms. Bielecki is released in this case, she will be in late middle age, approaching senior citizen status. When she is released, there needs to be a significant amount of suspended time hanging over her head to deter her from engaging in any further criminal conduct. As to the circumstances of the offenses, the extent to which these murders harmed the victims cannot be overstated. She ended her children's lives, and she inflicted lasting, irreversible harm on the families. The sentence must address deterrence and is focused specifically with regard to the suspended time on deterring Ms. Bielecki when she is released. Her initial period of incarceration is for 45 years. The amount of suspended time hanging over her head should be for at least as long. The probation conditions are designed to protect vulnerable children who cannot protect themselves. A significant amount of suspended time hanging over her head is designed to deter her from violating the conditions. If she does violate them, she should understand that she will be risking incarceration, potentially for up to the rest of her life. The sentence must also reflect community condemnation and the reaffirmation of societal norms. Community condemnation for the murder of a child by a mother could not be higher. And here, Ms. Bielecki murdered both of her children in 2 separate premeditated incidents. Finally, the court must consider restoration of the victim and the community. There is nothing the court can do or say that will restore or ameliorate the harm the victims and the families have suffered. Regardless of the sentence the court imposes, it will not bring these children back. The harm the defendant has inflicted is so serious that it cannot be undone. The only small way in which the sentence can further restoration is to include a restitution requirement for any counseling, funeral expenses, or other expenses the families may have incurred as a result of the offenses and may wish to seek through the state. After considering all of these factors, the court places the greatest weight on the seriousness of the offenses, the need for deterrence, and the fact that the unexplained and unprovoked violence underlying these crimes supports the conclusion that Ms. Bielecki is seriously disturbed and unusually dangerous. In these circumstances, the amount of suspended time must be significant enough to deter Ms. Bielecki from violating the conditions of her probation or endangering any vulnerable children in the future. If she serves 45 years and has only another 30 years of suspended time hanging over her head, she may feel that the bulk of her sentence is behind her. The suspended time imposed must be significant enough to deter Ms. Bielecki from committing any future crimes. In other words, not that the bulk of her sentence is behind her, but that an even greater sentence potentially awaits if she engages in future offenses. For these reasons, the court will impose sentence as follows. On count 2, CTN 004, murder in the second degree, the sentence will be 65 years with 40 years suspended, 25 years to serve. On count 5, CTN 006, murder in the second degree, the sentence will be 65 years with 45 years suspended, 20 years to serve. Both the active time to serve and the suspended time will be consecutive. The composite sentence is 130 years with 85 years suspended, 45 years to serve. Ms. Bielecki will receive credit for time already served in this case. On both counts, she will also be placed on probation for a period of 10 years. Based on the date of arrest in the pre-sentence report, Ms. Bielecki may be eligible to apply for discretionary parole under Alaska Statute 33-16-090-B6A after she serves 40 years of her sentence on approximately August 30 of 2058. Under the version of Alaska Statute 33-20-010 applicable to Ms. Bielecki's offenses, she may be eligible for mandatory parole on approximately August 30th of 2048. The court has no control over the mandatory parole provisions enacted by the legislature. There are also mandatory surcharges that the court must impose. Those are a $100 police training surcharge and a $100 jail surcharge with an additional $100 suspended. Because this is a felony conviction, Ms. Bielecki will be required to submit a DNA sample upon request to the Department of Public Safety. We also need to get fingerprints for the judgment. Officer, if you would. All right, fingerprints have been taken for the record. Any bail not previously forfeited is exonerated. Ms. Bielecki, you do have the right to appeal any portions of the sentence that were not part of your agreement with the state. If you wish to file an appeal, it needs to be filed within 30 days of the date of the written judgment, and you should talk to your attorney about that. Anything else in this case today from the state?
I don't believe so, thank you.
Mr. Reset? All right. Madam Clerk, anything else? All right. Thank you, everyone. We can go off.
So the 2 counts of second-degree murder, she was sentenced for each of those counts consecutive. That means they go one after the other. They're not concurrent in this case. A total of 130 years, Michael, 85 years suspended, 45 years to serve. The most, this is what the state requested. So it's extreme, but given the circumstances and the guilty pleas to these 2 deaths, I'm not surprised.
Feels very appropriate to me. The thing that I'm a little concerned with, the judge said, according to Alaska law, there's mandatory parole, could come up at some point. She wasn't sure if it would apply, but in 2048, she may be eligible for mandatory parole. That's only 24 years.
Yeah.
That's only 24 years from now. She may be out of prison. 24 years, I think, not enough time under these circumstances, so we'll have to, see how that plays out. But I think the sentence as laid down by the judge is appropriate.
I think so, too. Interesting, the judge certainly put on the record, this is something I have no control over, this mandatory parole. It's part of the law.